Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about criminal law and family law. Cases that should have gone to the Supreme Court of Canada, but didn't. In the context of divorce proceedings, a woman alleged that her husband had committed domestic violence against her. This was going to be a relevant factor in the separation and family trial. In the criminal trial, the husband was acquitted of the domestic violence, meaning that he got a finding that he was not guilty of the offense. He argued in the family trial that the evidence of domestic violence should not be accepted because he was entitled to be presumed innocent of that. Despite this, the trial judge on the family law trial found that he had committed domestic violence and made certain orders against him as a result of that. And this case raises very important issues. The right to be presumed innocent is a right that anybody charged with an offense has, but the scope of that right is constrained by its use by the state against an individual, not by its use by private parties litigating against each other in the context of a family law dispute. But if the allegation of domestic violence is brought into the family law proceedings in court, does it not engage the charter right to be presumed innocent? And with the finding of not guilty in the criminal trial, thus the ongoing right to be presumed innocent of that otherwise criminal allegation? If the state is the one determining the facts of the situation through a state-funded, state-set-out court system, should the state not apply that same presumption of innocence? Is it engaged in the family law context? And this was an important opportunity as well for the Supreme Court of Canada to look at the different ways in which allegations of domestic violence may arise, whether they be in the context of criminal cases where the standard of proof is the highest it can be at beyond a reasonable doubt, or the family law context where the standard of proof is a lot lower on a balance of probabilities, and raising the issues of relitigating certain events, and whether there are any consequences to a family law finding of domestic violence that corresponds or conflicts, as the case may be, with a criminal court finding of domestic violence. All of these things were important issues for the Supreme Court of Canada to address. We know that these types of allegations are made in courthouses across this country every single day, and a determination on how and to what extent determinations in a criminal trial may play a role in the family proceeding and vice versa has significance in the context of work that our courts are doing on a day-in, day-out basis. The Supreme Court of Canada should have recognized this as an important issue that has the ability to affect thousands of Canadians every single day, and the ability to affect tens of thousands of cases that are currently ongoing in the system, never mind all of the cases that are going to be brought forward in the years to come. And unfortunately, the Supreme Court of Canada missed the opportunity to really clarify the relationship between the rights in the criminal trial process, the issue of judicial determinations in the criminal trial process, and the way that they play a role in shaping the family law process and determinations that can be made in family court. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.